tourism has increased. So what's the impediment then? What's the constitutional logic, mullahs, or basis on the basis of which you can deny the people of Kashmir a statehood, and mullahs, India is a union of states. As your lordship rightly said, my lord the Chief Justice, that a union territory can get the status of a state, but not the other way around. It's never happened in the history of this country. Actually, 272, 273, all this has never happened in the history of this country. Not even during emergency. So, mullahs, just one last thing, and then I'm done. I want to show you the annexures in this, mullahs. This is my argument on three, mullahs. Others will deal with it in some form. I want to show just one. Yes, kindly see PDF 42. Now, this is dated 17th May 1949. Well, as your lordship will notice here, and this is all documents are provided in the annexures, that at this point in time, Iyengar, Sheikh Abdullah, and Vallabhbhai Patel and Nehru were all getting together to draft 370. And on 17th May 1949 is a letter written by Gopalaswamy Iyengar, and he tells Vallabhbhai, here's the draft. Jawaharlal ji has seen and approved of it. Will you kindly let Jawaharlal ji know, direct as to your approval of it? No, directly tell him as to your approval of it. He will issue the letter to Sheikh Abdullah only after receiving your approval. Vallabhbhai Patel was the architect of 370. Nothing was done without his approval. In fact, he went to Parliament. Kindly see, there's another letter, another document here. 3rd November? Yes. It's very interesting with us. 3rd November. No, not 3rd November. No, yes, 3rd. Yes, where is it? Yes.
But look at Sardar Patel's letter at page 47, 46.
46, yes. Correct. That's the draft, mullahs, of 306A. Kindly come to 244, mullahs.
Right, that's that letter.
Thank you for your letter of 15th, which I have received only this afternoon on my return from the Constitution. 1 second. I find there are some substantial changes over the original draft, particularly in regard to the applicability of fundamental rights and directive principles. You can yourself realize the anomaly of the state becoming part of India and at the same time not recognizing any of these provisions. I do not at all like any change after our party has approved of the whole arrangement in the presence of Sheikh Saab himself. Whenever the Sheikh Saab wishes to back out, he always confronts us with his duty to the people. Of course, he owes no duty to India or to the Indian government or even on his personal basis to you and the Prime Minister, who have gone all out to accommodate him. In these circumstances, any question of my approval does not arise. If you feel it is right thing to do, you can go ahead and do it. Now, see the next document, 3rd November. There was some, again, this is by Vallabhbhai Patel. There was some difficulty about the provision relating to Kashmir. Sheikh Saab went back on the agreement which he had reached with you in regard to the provision relating to Kashmir. He insisted on certain changes of a fundamental character, which would exclude in their application to Kashmir the provisions relating to citizenship and fundamental rights and make it necessary in all these matters as well as others not covered by the accession to 3 subject to seek the concurrence of the state government, which is sought to define as the Maharaja acting on the aid and advice of Council of Ministers appointed under the proclamation on 8 March 1948. After a great deal of discussion, I could persuade the party to accept all the changes except the last one. He was the one who was interacting with the party. And he was the one who finally, mullahs, persuaded the party to accept all the changes except one. And of course, Sheikh Abdullah thereafter.
Sure, there was a political compromise to ensure enough flexibility at later
absolutely. All I'm saying is, everybody was part of that process.
You are accepting the second part also, that there was flexibility to ensure that in future it works itself out.
That's correct. Well, all that I'm saying is, they were all collaborating the key players were collaborating in drafting 370, and this is how they understood 370.
That argument you have already.
Yeah, I've already made. I'm not repeating it, Mulad. I just wanted to read these letters. So, Mulad, and then I've got this table, Mulad, of Jammu Kashmir, Mulad, where Jammu Kashmir is the head of most of the states in India in every parameter. But we are not concerned with that, Mulad. I just put it. So that's all I have to say, Mulad. I just want to say at the end that, Mulad, as I said, Mulad, your lordships, Mulad, ultimately is the arbiter of what this constitution should look like and how it's to be interpreted. But I only want to request your lordships to think of one thing, that as I walk out in silence of this court, let the court speak on behalf of the people of India. Because this court, this government, or any government, any administration acts for the people of India. And it should not be that acts are done when a part of the people of India are silent, who have never been consulted, and whose fate will be decided by the cabinet sitting here without reference to parliament, without reference to legislature, without reference to the people. Those people are central to the Constitution of India. We should not forget that. Thank you very much for giving me this time. Excuse me for a while, but let's fill it up.
Mr. Subramaniam, you'd be arguing.
Yes, my lord. My lord, am I audible? Am I visible?
Vote, Mr. Subramaniam.
Yes.
Thank you, my lord. My lord, I just want to make a few brief submissions on Article 370 in the light of your lordship's questions and observations. My lord, it might have begun as a temporal provision initially. I don't think anybody can dispute that people envisaged it as of temporality. But, my lord, the provision had adequate evidence, intrinsic evidence in its words to suggest that it could be there to stay. And that is what has happened. And my lord, this is the crux of the matter. Has it happened in a manner known to Article 370? My answer, my lord, is yes. In a manner known to Article 370, Article 370 stays. Now, my lord, how has this been achieved? As your lordships would notice, that it was a Constituent Assembly of India which gave the people of Jammu and Kashmir the ability to determine their political future through a constitution. The instrument of accession, my lord, did not completely transfer sovereignty, as held by Justice Gajendra Gatkar in Pramnath Kaul's case. The instrument of accession itself had reservations that it was intended to abide by a future constitution, a future determination by the people of India, which is why Justice Gajendra Gatkar said that until the 1939 constitution was there, the Maharaja was still enjoying a certain kind of sovereignty to make laws, and therefore, my lord, upheld the law in question. Now, my lord, When does integration become complete is the question. And, my lord, in this case, unlike the cases of Privy Purses, unlike any other case, the sovereignty actually transfers from the king, from the monarch, to the people. And this transition from the monarch to the people is the common framework of both the Constituent Assembly of India and a Constituent Assembly to be formed. The notification of 25th November 1949, my lord, expressly uses the words Constitution as applicable, or insofar as is applicable, because that is how Article 306A of the draft Constitution presaged it. Well, on Article 306A is the only article which refers to the instrument of accession and refers to the matters contained in the instrument of accession as limiting the power of Parliament to make laws. Therefore, my lord, the instrument of accession expressly finds a place in Article 371 of the Constitution. The expression Constituent Assembly also finds a place in Article 370 of the Constitution. But there was a very important question which the Chief Justice has voiced on a few occasions. What is there to show that the Indian Constitution recognized the Jammu and Kashmir Constitution? I thought it was a very critical question, and I have, my lord, two answers. The Constitution does recognize the Jammu and Kashmir Constitution. May I invite your lordship's attention to the text of Article 370 itself that recognizes, my lord, that Constitution. Please, my lord, look at Article 370 with me for a moment. In Article 370, after subarticle 1, 2, and if your lordship sees 2, if the concurrence of the government of the state referred to in para 2 of subclause B of clause 1, or in the second proviso to subclause D of that clause, be given before the Constituent Assembly, and may I request, my lord, your lordships to look at the next few words. For the purpose of framing the Constitution of the state is convened. Constitution of the state, my lord, is no other constitution except the Jammu and Kashmir Constitution. And, my lord, there is a second piece of evidence in the Constitution which has not yet been brought to your lordship's attention. There was, my lord, the state reorganization in 1956. The concept of Part B, Part C, all of them disappeared, if your lordships recollect. The Constitution's 7th Amendment Act, my lord, in Article 152, inserted the words excluding the state of Jammu and Kashmir. In Article 152. This is, my lord, 7th Amendment. And, my lord, the dates are slightly significant. Very important, my lord, is the date. The 7th Amendment was assented, my lord, on the 19th of October 1956. And, my lord, by this time, the draft constitution of Jammu and Kashmir was introduced on 10/10/1956. And the draft constitution of Jammu and Kashmir established the High Courts of Record and established the legislature under its constitution.
What happened on 10/10/56, Mr.?
In 1056, my lord, the draft constitution of Jammu and Kashmir was introduced for adoption. And that constitution, my lord, clearly had provisions for executive, the legislature, and the judiciary to be established in terms of that constitution. So institutions, my lord, were established under that constitution. And therefore, Part 6 was rendered inapplicable by the insertion of the words in the Constitution's 7th Amendment Act, excluding the state of Jammu and Kashmir. So, my lords, it was a very valid question that your lordships put to us. Is there any evidence, apart from conduct, which I'll deal with separately, in terms of constitutional conduct, that the Constitution of Jammu and Kashmir is alluded or is cognitively taken note of? It is alluded in the words in my submission in Sub-Article 2. It is cognitively taken note of because that chapter relating to Part 6 was rendered inapplicable under Article 152, which is why your lordships notice now the CO 273, it seeks to exclude that exclusion. It refers to 152. It says, notwithstanding anything in this constitution. So, my lord, I submit that the Jammu and Kashmir constitution does find a place. But let's come to a more critical point about the word recommendation in Sub-Article 3 and whether Sub-Article 3 was in fact employed. This is a very critical question your lordships asked. The word recommendation, my lord, was chosen consciously because the Constituent Assembly of Jammu and Kashmir, my lord, was not constituted by the Government of India or any initiative of the Government of India. It was under a proclamation of the Maharaja under the Jammu and Kashmir Constitution. That Constituent Assembly, my lord, was not an emanation of the Government of India's Act. Second, my lord, an order which had to be issued under Article 371 necessarily had to be an order in the name of the President. And that's, my lord, because all executive power vests in the President. The argument of President being answerable to Parliament, I'm sorry, my lord, with respect, is completely contrary to the decisions of this court with reference to the Westminster style of government which we have adopted, which Dr. Ambedkar on the 4th of November, when he introduced the Constitution, he spoke about the role of the President. And, my lord, I submit, under Article 81, the President, my lord, is a part of Parliament. I was a little surprised, my lord, to say the President is answerable. My lord, he is a part of the Parliament. Parliament, by very definition, includes the President and two houses, my lord. And under our constitution, my lord, the president can never act without the aid and advice of the Council of Ministers. The governors could, under Shamsher Singh, but not the president. So, my lord, a claim of untrammeled discretion and power in the president under Article 371 itself, my lord, is flawed. But now, my lord, let's see how events have played out. Your lordships wanted to know, was sub-Article 3 employed? Was there anything to show that it was effectuated? And I say, my lord, it was effectuated in 4 different ways. The summum bonum of all the 4 steps is it was effectuated. And, my lord, the decision to abrogate Article 370 cannot be taken ad nauseam. It was meant to be taken once. It had to be taken by the Constituent Assembly. Now, my lord, let us look for evidence of it. The first is, please look at, my lord, CO. If your lordships will look at CO 42. Would your lordships kindly go to the documents volume for a moment? Please go to, my lord, document volume 3. And would your lordships kindly come at page 12 of the PDF. CO 44, I'm sorry, CO 44. Please see, my lord, this. My lord, this is on the recommendation of the Constituent Assembly. PDF 12, my lord. And if your lordship says this is a declaration under Article 373 of the Constitution, and if your lordship now sees the declaration, in exercise of the powers conferred by Clause 3 of Article 370 of the Constitution of India, the President, on the recommendation of the Constituent Assembly of the State of Jammu and Kashmir, is pleased to declare that as from the 17th day of November 1952, the said article shall be operative, with the modification that for the explanation in clause 1 thereof, the following explanation is substituted, which, my lord, is about the Sadr-e-Riyasat. But, my lord, this is a decision under 373. What was the next decision? The next decision, my lord, was again a recommendation of the Constituent Assembly, namely an invitation, my lord, to apply the provisions of the Constitution of India subject to certain modifications. That was a decision, my lord, again of the Constituent Assembly. It was a resolution of the Constituent Assembly. And that, my lord, is significant because that resolution was on the 15th of February 1954. Your lordships will find that in volume D7 at page 978, and it was adopted in, my lord, D7, page 979. That annexure, my lord, which was the annexure attached to the report of the drafting committee, was tabled in the Constituent Assembly.
Where do we get it? At page two?
My Lord, volume D7. Has your Lordship a volume D7?
PDF?
Yes. My Lord,
979.
could your Lordships first see volume D7 at page 937? Let me show that first.
937.
Yes, first 937, and then I'll show you, my Lord, the resolution.
That's the report of the drafting committee?
Yes, this, my Lord, was tabled before the Constituent Assembly. And in this report of the drafting committee, your Lordships will notice at 938, PDF 938, would your Lordships look at the first sentence? The provisions of the Constitution of India, which in addition to Article 1 and Article 370 should apply in relation to the state of Jammu and Kashmir and the exceptions and modifications subject to which they should so apply will be as follows. And then, my Lord, all these are extracted. But what's important, my Lord, is Article 1 and Article 370 in addition. This, my Lord, is introduced on the 11th of February 1954. And on 15th of February 1954, if your Lordships go to page 978, my Lords, of the same volume, this was adopted. So, my Lord, the first body which looked at the matter was the Constituent Assembly. They invited the application of the provisions of the Indian Constitution. And at 978, your Lordships will see at the bottom of the page. Please look at the bottom, my Lord. Resolution that having adopted the report of the drafting committee this day, the 15th of February 54, and having thus given its concurrence to the application of the provisions of the Constitution of India in the annexure to the aforesaid report, this Assembly authorizes that government of the state to forward a copy of the said annexure to the government of India for appropriate action. And that is how, my Lord, on the 14th of May 1954, the 1954 order was passed. And your Lordships will notice the words of that order. It's in volume D3, my Lord, at page 13. Your Lordships will notice
Volume 3,
that,
page number, volume 3.
yes, volume D3, page 13, my Lord.
Okay.
Your Lordships will find an express continuance of Article 370. Please see page 13. This is the 54 order.
Yes.
And please come to 2. The provisions of the Constitution, which in addition to Article 1 and Article 370 shall apply in relation to the state of Jammu and Kashmir and the exceptions and modifications subject to which they shall so apply shall be as follows. And, my Lord, this order of 1954 was again tabled before the Constituent Assembly. If your Lordships go to volume D7 at page 990.
Circle 371, not 373.
And at page 990, my Lord, your Lordships will notice that in the Constituent Assembly, the 1954 order is laid on the floor of the House. Please see 990, Mr. Dogra. The recommendations of the House in this behalf had been sent to the President of India, who in exercise of the powers conferred under Clause 1 of Article 370 was pleased to issue Constitution Order 1954. I lay the copy of this order on the table of the House. As I told your lordships a little while earlier, the draft constitution, my lord, of Jammu and Kashmir was introduced by Mr. Dogra on 10/10/1956. Your lordships will find in the same volume at page 1058. In that same volume. Your lordships will see 1058 PDF.
Page number, please repeat.
Page number 1058 PDF, my lord, in volume D7. Otherwise, it has a red lettered page of 2417.
That's it.
And your lordships will notice, Mr. Dogra, sir, I beg to present the report of the drafting committee and introduce the draft constitution as settled by the committee. And your lordships may just see 4 lines later. The fundamental principle on which the draft is based are parliamentary democracy, responsibility of the executive to the legislature, joint responsibility of the cabinet, separation of the various powers of the state, executive, legislative, and judicial, and finally, the rule of law. One basic feature of the Constitution is that we have once again affirmed that the state is an integral and inalienable part of India and will ever remain so. There was a very thoughtful observation from my Lord Justice Gavai on Dr. Ambedkar's contrast of different models of federalism. But Dr. Ambedkar does say even the Indian Constitution shares sovereignty between the center and the states. However, it does not have the same nature of the American Constitution. It comes to an end there because they have separate constitutions for each state and they have citizenship for each state. But, my lord, here, the word which is used is only permanent resident, not citizen, my lord. All Jammu and Kashmir residents governed by that constitution claimed and asserted that they are Indian citizens. I'm going to show that, my lord, in a moment. Now, this, my lord, is the draft constitution. Now, would your lordships kindly come to 1910-56? You just have to look at Article 152 in your, my lord, in the Constitution. Please have a look at Article 152.
What is the date, Mr. Subramaniam?
That, my lord, came on 19th October 1956. Your lordships will find that at page 101 of the Constitution, PDF.
That is the 7th Amendment.
That is the 7th Amendment, my lord.
And it came into force on 1st of November 1956.
Absolutely, my lord. And your lordships will notice the parentheses